details. We have some breaking news that's coming in. All right, the big breaking news coming in. The SC upholds harsh provisions of the PMLA, which was challenged by 241 petitions. Now, this is the big breaking news that we are bringing to you at this point in time. The Supreme Court has upheld the harsh provisions of PMLA, which was challenged by 241 petitions. This is the news that we are getting to at this time. We are still awaiting more details, but this is the big breaking news that is coming in. At this point in time, the Supreme Court has upheld harsh provisions of the PMLA, which was challenged by the 241 petitions. Now, we will have to wait and see how the cases that are currently underway are going to be impacted by this. But what we do know as of now is that the Supreme Court, the top court, has upheld the harsh provisions of the PMLA, which was challenged by the 21 petitions. My colleague Meenakshi is joining us on the phone line for more on this. Meenakshi, big breaking news coming in that the Supreme Court has upheld the harsh provisions of PMLA, which was challenged by 241 petitions. If you could take us through all the details.
Was a clutch of petitions which three-judge composition bench of the Supreme Court led by Honorable Justice Khanvilkar is in the midst of pronouncement. As we speak, the orders are still being pronounced on this one, but various provisions of the PMLA, which the Supreme Court just moments back has gone ahead and upheld the validity of various provisions of the PMLA Act. And the Supreme Court has said that the stringent conditions for bail under the PMLA is legal and not arbitrary. It passed this order, we just mentioned, around a clutch of 241 petitions that were filed by various accused. And with this, what is hugely interesting is that this will be a shot in the arm for this particular act. This is a statute act. Remember, this is a specially carved act for a lot of offences for which, like you just said, there are 241 petitions that were filed by various accused in this matter. But clearly the Supreme Court is of the opinion that enough safeguards exist, and therefore there is no requirement for any tinkering with this particular law. And very quickly, a little backgrounder for our viewers. What had transpired earlier was the Supreme Court had heard arguments for about a month consistently on this, where the Supreme Court had gone ahead and heard, all the contentious arguments pertaining to Section 3, Section 5, Section 11, Section 19 of the PMLA Act, Section 45 of the PMLA Act, which lays down that where a public prosecutor opposes a bail application of an accused, the court can grant bail only if it is satisfied that there are reasonable grounds for believing that the accused is not guilty of such an offence and that he is not likely to commit any offence while on bail. So these are the various provisions of the PMLA that was under challenge before the Supreme Court, which the court has just ruled on. And, it has gone ahead and upheld the various stringent provisions of the PMLA.
Right, Meenakshi, many thanks for taking us through all those details. All right, this is the big breaking news that we are getting to at this point in time. The Supreme Court has upheld the harsh provisions of the PMLA. And the Supreme Court is hearing a batch of petitions concerning the interpretations of provisions of the anti-money laundering law. And we are learning now that the Supreme Court has in fact upheld the harsh provisions of PMLA, which was challenged by 241 petitions. So the big Supreme Court judgment is out. The Supreme Court, the top court, has in fact upheld the provisions, the harsh provisions of the PMLA, which was challenged by 241 petitions. Right. The Supreme Court has upheld the validity of various provisions of Prevention of Money Laundering Act, and the Supreme Court says that the stringent conditions for bail under the Act is not legal and not is legal and not arbitrary. It passed the order on around 241 petitions filed by various accused. All right, I'm being joined by Naveen Chomal, who's a lawyer. Many thanks for joining us on the broadcast. Sir, if you could please help break this down for us. We are picking up right now that the Supreme Court has upheld the various harsh provisions of the PMLA, which was challenged by the 241 petitions.
We try to explain to all our esteemed viewers in a very simple manner, lucid manner, the PMLA, the Prevention of Money Laundering Act, as we can understand from the very name of the act, and its aim is to prevent the money laundering. And the offences are what are regarding the cleaning of money, the laundering of money, which is being generated through crimes. So this particular act is dealing with the crimes, and they are not just ordinary kinds of cheating individuals, but these are crimes of very high magnitude against our nation, where the money of the nation is sent abroad also. The nation suffers or society suffers. So this particular act is of a very serious consequence and is involving the money generated from various criminal activities, which is hidden and tried to be converted into a white money. So there are certain stringent provisions in the law, including the penal provisions. So when there are penal provisions, there ought to be a power to arrest. So it is totally illogical to say and come to the Supreme Court saying that the ED does not have any power or any teeth to arrest. So ultimately, even in the case of Bhujbal, we have seen Minister Bhujbal was arrested in the scam of Maharashtra Southern in Delhi. We have seen the Supreme Court upholding his arrest. So we have seen so many cases, one after another. So this particular slew of cases which are filed in the Supreme Court for consideration and asking a new question to the Supreme Court were basically inherently weak, inherently illogical, and they're totally defying the concept of enforcement directives, powers under the PMLA, Prevention of Money Laundering Act.
Right.
So ultimately, we are thankful to the Supreme Court. Of course, it was expected the Supreme Court would turn down these petitions, and unfortunately, Sonia Gandhi will not have any relief in the matter.
Right, right, sir. So we're also being joined by Geeta Luthra, senior lawyer on the broadcast. Thank you, ma'am, for joining us. Ma'am, there is some big breaking news that we're getting that the Supreme Court has upheld the harsh provisions of the PMLA, which was challenged by 241 petitions. What do you have to say about that?
So the fact is, this PMLA Act has gone up, down, zigzag in many ways. And in fact, I think it was Mr. Chidambaram who had made a statement in Parliament once with regard to it being made non-cognizable. Now, having said all that, the last word before this was Nikesh Tarachand Shah, which was, I think, a bench of Justice Nariman with regard to twin conditions. I have not obviously gone through the judgment. I feel that then the only aspect that we need to look at is if the provisions have been upheld is somehow the aspect of interpretation and procedural follow-up has to be extremely strict so that the rights of a citizen are protected. Today, you are seeing PMLAs being invoked in every second case. So we have to ensure that somehow or the other, the citizen and the personal liberty of a citizen are not prejudiced in any manner while those conditions have been upheld. I mean, the Supreme Court's judgment is there and we have to respect it. whether anyone will then file a review or file a curative is for any of those 241 petitioners to see. And, well, let's see what the future holds.
Right, ma'am. And also the top court has very categorically said that stringent conditions for bail under the Act is legal and not arbitrary.
Yes, yes. So it is, of course, not arbitrary, but you see, after Nikesh Tarachand Shah, those two twin conditions which had been struck down by Justice Nariman's bench had paved the way for other cases where such conditions of reversal of right of bail, not jail, etc. And so I'll have to see the judgment to actually, give a more detailed comment. But coming on the heels of the judgment by Justice Kaul's bench, where they have said that there should be a special enactment for bail and that bail has to be something which has to be an entrenched personal liberty, that all these enactments or these judgments will have to be looked at in the light of each other.
Joining us in the broadcast and sharing your views. All right, going back to Mr. Naveen Chomal. Mr. Chomal, if you could please, break down for our viewers what the main contentions of the petitioners really were.
See, let me give the background to the entire matter. PMLA, as I was saying just a short while back, is definitely a very stringent provision. Ultimately, you see, in our jurisprudence of crime, criminal jurisprudence, we have different theories of punishments and deterrence. So this particular crime and the stringent provisions are based on the deterrent theory, that anyone who commits the crime of such a serious nature will have to be put behind bars and they cannot be given bail so easily. So there is a certain deterrence to the people to commit these crimes. For example, this is the similar deterrence which is available to the people doing the crimes in the Narcotics and Psychotropic Substances Act also, Anti-PACE Act also, and other provisions also where there was terrorism involved like UAPA. So this particular act is also giving a message to society that anybody who indulges in crimes of such a high magnitude will have to face serious consequences of the law. And you see, ultimately, the act was very strict about not giving bail to the accused persons. So as rightly pointed out by my other co-panelists, that in the judgment of Justice Nariman, the particular provision was interpreted, and because of which many accused people started getting the benefits. They were granted bail subsequently. But it does not mean that the ED does not have or should not have power to arrest the people. That is the crux of the matter. So in this case, what has happened is several people had approached the Supreme Court. As you pointed out, 241 petitions were filed before the Honorable Supreme Court, which were decided today. So they were trying to challenge that these offences are of what you say, documentary nature, they are of civil nature. They should not be made of such a nature where the ED can arrest the people and put them behind bar, and the bail can be denied to them in a very strict manner. So, of course, Supreme Court will not get swayed by all such submissions and arguments. Supreme Court had to uphold the law, and ultimately there is a very sound principle of law and public policy that individual rights are no doubt very important, but the individual rights cannot, supersede the right of the society or the right of the interest of the nation. So ultimately, the interest of the nation, interest of the society will prevail over the individual rights. So the individual people are suspected to be, or there is a prima facie case, or there is a material against the individuals of having committed a crime of such a high magnitude. You kindly appreciate the seriousness of these allegations. This is a money generated from very serious crimes. and this money is then laundered, tried to be hidden and converted into white money. Much of the money is sent abroad also. There is a big loss to the revenue of the nation. Our foreign currency is getting depleted. So there is a big, long-term consequence on the entire society or nation. So definitely these steps cannot be taken so easily by the society. But I not agree with the co-panelists who try to say that it is action is being inflicted in every second case. That is not the case. And I appreciate thieves, if they are getting caught, cannot say that every thief is getting caught. Who is committing crime will be caught, and it lies in the interest of the nation. You look at the condition of a society, there was rampant corruption, and corruption has been a biggest hindrance in the progress of a nation. We individuals, you and I pay taxes, and if the politicians and the criminals, they rob our money, ultimately we are at loss, our future generation are at loss. So the law enforcing agencies will have to have power. They should act, they should arrest all the wrong people. So in fact, as a common citizen, we must cherish the Supreme Court's decision, and we should support the government's action against all wrong people. And if anybody is saying that it's a political vendetta, you see, you cannot chant the mantra political vendetta because every politician commits a crime. Ultimately, there are courts, you can point out that there is no crime committed by me. You cannot show distrust to the court. In the PMLA, there is a provision where a person can approach the court can scrutinize the cases. So ultimately, what Supreme Court has done, we are extremely happy about the decision.
Right. So many thanks for joining us on the broadcast and sharing your views.